Hey everyone, it's Zach. My case is Nunnery v. Awesome Toyota in Massachusetts, which is the jurisdiction. Facts of the case: Billy and Baxter Biz own a Toyota dealership as a general partnership. In their employee handbook, there is a rule stating that all keys for vehicles must be checked out with the receptionist whenever a car needs to be moved. Whoever moves the car would fill out a tag saying who's moving the car, for what purpose, where is he moving it, the date, time, all that pedigree information. Billy and Baxter hire Sammy Scrub as a car detailer, whose job is basically to clean the cars, make them look pretty for the customers. Scrub is given that same handbook, and in there is a phrase stating that any unauthorized use of any car is strictly prohibited. Continuing with facts, one day Scrub asked Rachel, receptionist, who is the receptionist, if he could borrow one of the loaner cars for his lunch break to go to his mom's house. The receptionist, the receptionist lets Scrub have the keys for his lunch break. She says that nobody really follows the rules of the handbook, and that as long as he brings it back quickly, everything should be fine. During his break, he rear-ends a bus full of nuns and orphans. They all suffer injuries. Awesome Toyota then says, no, we don't want no scrubs, and fires Rachel and Sammy. The Biz brothers, Awesome Toyota, Sammy, and Rachel are all sued. The two issues, issue number one, is Awesome Toyota liable for Scrub's action, or was Scrub an agent of the business at the time of the incident? Issue number two, are the owners, the Biz brothers, liable for Scrub's action? Was Scrub an agent of the owners? So the rule of law for issue number one, this case, Cobb v. Abbott, is a very similar case in which a driver was working for a business, and while he was off the clock, quote unquote, he ran into some people. The main difference being, instead of him driving a car, he was driving a horse carriage. But I know the language in this quote's a little confusing, but the big takeaway of it is the defendants, being the partners of this business, had no control over the driver. Therefore, he was not a true agent of the business at the time. Rule of law for issue one continuing. This case, State Trust Corporation v. Hall, cited the Uniform Partnership Act. In Section 9 of the Act, it basically cites that an agent is limited, cannot hold the partners for an act of the agent beyond the scope of his authority. That basically saying that you cannot hold the partners or the partnership responsible for the agent if the agent acts outside the scope of his authority. Now, Scrub's authority, his job description, was to detail the cars. Sure, he might need to move the cars in order to detail them, but in no way, shape, or form is it in his authority to take a key that he did not have permission to take from the owners themselves for personal reasons. Yes, the receptionist gave him permission, but it was not in her authority to do that either, because her authority for checking out the keys would be to move the car for business purposes, when Scrub actually took the loaner car for personal reasons, not for business reasons. In regards to issue number two, this case, Linton v. Hurley, all members of a partnership are liable for an injury occasioned by the negligence of servants employed by the partnership while transacting business of the firm. Now, I know this quote, some of you are going to say, but Zach, this quote directly contradicts what you've been saying this whole time. And it does, except for the thing I'm focusing on is the very last part of this quote, while transacting business of the firm. If Sammy Scrub was transacting business for the firm, the partnership and the partners may be liable. However, he was not. He was on his lunch break, and he took the car for personal reasons. In no way, shape, or form does that have anything to do with the firm itself. He was not transacting business. He was not taking the car to sell it to a potential buyer. He was not taking it to the bank. He was not taking it for any reasons but for reasons of his own. So therefore, the partnership cannot be held liable for that particular action. This case is going to reinforce the same gist of it. This particular case I'm citing, one of the partners actually committed fraud against his clients. Now the quotes read, "Partners are general agents of each other while transacting partnership business, and one partner is liable for tort of another committed in the course and within the scope of business firm." Second quote being, "In committing tortious act which is outside of the agency or common business, partner acts only for himself, and he alone is responsible for the consequences." Now, this particular case is basically saying that when a partner is conducting business, that partner is an agent of the business. Now, all employees are technically agents of the business when they are conducting business for that company. So, Scrub, in the fact that he is employed, is an agent of the company, but he was not an agent at the time of the incident because he was off the clock and he was doing personal business. Since he was outside of that agency or common business, he himself is responsible for the consequences of his tortuous act. Continuing on with issue number 2, this quote, Locke v. Stearns. Hey, Stearns. All members of a partnership are liable for fraud committed by an agent acting within the scope of his authority, sale, partnership, property. Now, I know this says fraud and not a different tort, but fraud is a tort. It is very similar to a lot of aspects with negligence and damages. You still suffer damages from fraud. So, again, stating scope of authority and sale of property. So, although Scrub wasn't selling property, it's still referring to the scope of his authority. Him being on lunch break and taking a car for personal reasons is not within the scope of his authority. Oh, sorry, guys. Application for both issues. Since Scrub is outside the scope of his authority in his employment, he is therefore, the owners have no authority over him because he was not acting as an agent for the business or for the owners at the time of the accident. The owners would be held liable if Sammy Scrub was conducting business for the company, but the accident was committed during his own personal time, in which he directly violated the employee handbook. So the owners didn't have true control over Sammy's actions at that time. So unfortunately, the best thing they could do was fire him once they found out that he violated the employee handbook. But since he was not conducting business for the firm, and he was acting completely outside the realm of his authority, or the scope of his authority, the owners and Awesome Toyota cannot be held liable for his actions. So conclusion, neither Awesome Toyota nor the Biz Brothers are held liable for Scrub's actions. And that's it, guys. I will include the hyperlinks and of the cases in my eCoursework post. I didn't think it'd be really useful to have them in the PowerPoint since you can't click on them. But yeah, that's it. Hope everyone has a good night. Bye.